All right, good morning, everybody. And we are back in session for an oral argument session at the 5th DCA. My name is Dan Traver. We are being broadcast and recorded on YouTube. This is our third of three cases this morning. It's case number 20-946, Loretta Barrett versus Cormac Barrett. I'd like to introduce my two fellow panelists. I'm joined today by Judge Rand Wallace and Judge Mary Nardella. Ms. Lippincott, I will assume that unless you tell me differently, that you'd like 5 minutes for rebuttal, and you may proceed at your convenience.
Thank you, Your Honor. Marcia Lippincott for Appellate Loretta Barrett. This appeal challenges a dissolution of marriage judgment. Now I'm going to be highlighting some of our challenges. These parties had a long-term marriage of 22 years.
Ms. Lippincott,
yes,
I kind of want to just get to it because you raised 20 issues on appeal. I want to focus you initially on your, I think, second equitable distribution argument, which relates to what you classify as the automatic conveyance statute.
Yes, Your Honor.
Is it your client's contention that the trial court did or did not convey sole possession of the marital home to her in the amended final judgment?
Did not, because they took away, the judge took away the automatic conveyance provided by the equitable distribution statute, and said,
so whether we call it an automatic conveyance or not, we're talking about 61075 sub 4, which
correct,
basically says that when the trial court awards somebody property in the context of equitable distribution, it conveys it at that particular time. And obviously I'm paraphrasing. The trial judge also in her amended final judgment specifically said in the final judgment, I am awarding sole property to each parties, and then references the equitable distribution worksheet at Exhibit C. I'm wondering whether, and I understand completely because both parties seem to agree that it was not conveyed entirely, but I'm wondering if maybe perhaps despite the trial judge's intentions, whatever they were, it happened anyway, that the property was conveyed based on the language in the judgment, and the trial court then put in this separate condition involving a quitclaim deed. Can you address that hypothesis?
well, yes, Your Honor, I want to direct your attention to the language of the judgment that I believe you were referencing at the end. It's on page 3408 of the final judgment, and says that within 15 days of receipt of the equalizing payment, the husband shall execute the deed. So no deed before then.
Do you need that deed is what I'm asking. If you've got the plain language of the statute, which says that it's yours, and you've got the language in the judgment saying that I'm awarding sole property, I'm wondering, in other words, is your concern at bottom a legal one or a practical one? Because if your client has, I should say, legal title to that property by virtue of the judgment in the statute, are you just complaining, practically speaking, and complaining is a harsh word, I don't mean it that way, are you just complaining that, hey, by virtue of this secondary condition, the house is inalienable because no broker, title insurer, or lender is going to touch this without a quitclaim deed?
I think the situation is clouded by the language of the judgment, clearly. You know, we have the clear language of the statute, and this judgment interferes with that. And the way that I believe both sides have interpreted it is that the language in the judgment takes away from the automatic conveyance language, because it clearly says he gives her title to the deed after the equitable distribution payment.
I think that presupposes, though, doesn't it, that the deed is what transfers and divests his interest in the marital property. What is the effect of that if it's already been divested.
At the very least, it muddies the situation. When you say already divested, it would only be by the final judgment, and the final judgment at the very least is unclear. And you know how those title companies want it. They want things clear. This is far from clear. It's messy. It's contradictory.
I don't dispute that. I just wonder if you've got a valid legal argument that the trial court erred here. I understand your practical considerations.
Ms. Lipcott, how is the house owned currently in your view? What is the character of the ownership currently of the house?
Both parties.
And tenants in common?
Like it was before, yeah. Just like it was before.
Tenants by the entirety or tenants in common?
They both had title, so I presume tenants by the entirety. But I don't think it was changed by this judgment, because this judgment and the statute together makes it unclear at the very least. And
so if your client were to pass away, Mr. Barrett would have an estate claim on the house?
Yes. So I don't see how we can get away from, at the very least, that what the judge did was to create an unclear situation where the statute tried to make it absolutely clear. There was no basis for her to do that. And I want to get right to the heart of things too, but I'd like to go back to alimony, because I think that actually is perhaps our major issue here. First, the trial court judge did not find the amount of the need. And this court has said that finding the amount of the need is critical, and that's an error of law. So we have that problem. And then what the court did was that it made a number of findings to support its alimony award. And the trial court limited the alimony award to the amount it found was the husband's monthly surplus, or $1,500. And Your Honors, there is no record in this. There's no evidence in this record to support that finding. First, look at the amount that the court found that this husband earned. A gross of $14,447. And what she did was she looked at the expenses in his last financial affidavit, dated January 23rd, 2019, where he claimed only a gross income of $6,700. And under those circumstances, he claimed expenses in the $8,000 range. So we have much more than a surplus of $1,500. His affidavit shows a monthly allowance for his son of $350. And then there's an exhibit that he created, and that's Petitioner's Exhibit 6, found at the record at page 1251. Now, it's important for everyone to realize that that's the very same chart that was created by the husband for a temporary hearing held in March of 2019. And that was the husband's exhibit number 2. That can be found in the record on appeal at record 788. And this exhibit shows the son's car lease of $320, insurance for the son is $336, and the wife's insurance is $321. But this chart also shows a total of $3,000 monthly that includes marital home expenses. So the competent substantial evidence here does not support the court's finding limiting the monthly surplus to $1,500 per month. It was much more. The trial court also found that the wife could resume her career as a dietitian, but there's no evidence to support this finding.
What's the negative effect of that finding on your client when minimum wage was imputed?
The future. It says clearly she can go back to work as a dietitian when the only person who testified that about the topic at all was the wife, and she clearly testified that she worked 15 years ago. Now, in the current field, she needs a master's degree, which she doesn't have. So, yes, I understand that the judge only imputed a minimum wage, but it sets her up for the future when this is not true. So it's a finding that needs to be fixed. The trial court also found that the wife used money that the husband gave to the wife to pay home taxes for tuition for the party's adult children when they could have gotten loans. Again, the evidence does not support this finding. The party's CFE fund was historically used to pay for the children's college education. And there was no evidence that the party's children could have gotten additional loans for the $35,000 owed. There was no evidence that the husband gave money to the wife, or that he told the wife not to use the money in this fund to pay the children's college. This is what's historically had been done. The money was there and the wife just followed the history. And the husband offers no response in the answer brief. The amount of alimony here, $1,500, is simply woefully inadequate. Every case that I could find having anywhere near similar circumstances showed how inadequate this sum was. And if we just look at, take his needs and half them, that's about $4,300, according to his financial affidavit. And we don't think that's right, but just take that amount. Here she was left with $1,500 in the future. Remember that she doesn't even get immediate alimony, according to this judgment. No, the trial court judge abated that alimony improperly until she could make an equitable distribution payment that even the husband says that she can't afford to do that. She can't afford to do that until she sells the house. So, and this $8 per hour minimum wage, her income would be insufficient to even meet half of what reasonable needs would be, according to the husband. In addition, there was no analysis made of the retroactive period. It has to be made just like the current ongoing alimony amount needed to be determined. Here, the trial court judge said no, she got at least the $1,500 I've awarded. And so that's it. I'm not going to make the analysis. That was clear legal error. In addition, there was no decision on life insurance. She asked for it. There should at least have been a decision. There wasn't. Here we have a wife who is unable to support herself in a reasonable fashion.
Ms. Lippert,
And
what
sure.
was the request for the wife about life insurance? Is she asking the husband to maintain his current policy or to purchase a new policy? And if it's to purchase a new policy, did she need to put evidence in the record as to availability and cost of the new policy?
Your Honor, you're correct. There was no evidence except for the fact that we know from the record that he does have life insurance and he pays $50 a month for it. And so I believe on the record, the only thing we could claim is to maintain that existing insurance. And no, we don't know. We don't know from this record how much it was. But at the very least, the wife deserved a decision from the court, and we didn't get one. In addition to our complaint about the automatic conveyancing statute, we argued that this judgment needs clarification about the attorney's fee award. In the findings section of the judgment, it says that the $40,000 awarded as attorney's fees shall be deducted from the equalizing payment. But there is no such language in the ordered and adjudged section. So we just asked that this be clarified, and the husband makes no argument in opposition to that. Now, moving along, we also have marital home furnishings. Now, the court initially found those furnishings as worth $40,000. Then the wife filed a rehearing motion challenging that value, and the trial court increased that amount with no hearing. And the value should not have been increased without a hearing, without due process. There's no competent substantial evidence that supports a valuation of $45,000. I want to skip along here as my time is waning to attorney's fees. Again, the trial court makes several findings that are not supported by the evidence. Things like unnecessary plane tickets when there is no such evidence. Unnecessary litigation of which there was no such evidence. She points to the wife's rehearing motions, yet the wife didn't even file, the husband did not even file a response. So there was simply no basis for these findings. In addition, the trial court found that the wife wasn't entitled to any award for the husband's misconduct. Yet she found that his income was more than double the amount that he claimed on his financial affidavit. And Florida's dissolution of marriage arrangement is based upon a party's obligation to fully and fairly disclose assets and finances. Each party is legally required to amend their answers to provide that information. Here, the husband claims he only made $6,700. The trial court found almost $15,000 per month. So this is a clear example of litigation misconduct. The failure to fully and fairly report his income, it's deception, pure and simple. The trial court found the husband had seriously failed in this obligation, but yet she ignored that fact when she was awarding fees. This needs to be corrected. She also found that the husband should only pay $40,000. Here we have a husband where she found that he earned a gross yearly amount of $173,000. She awarded $18,000 in alimony to be paid sometime in the future and imputed a minimum wage income. The wife, it was uncontroverted, had borrowed hundreds of thousands of dollars from her sister. Nice that her sister could help support her, but there was no controversy of the fact that she owed this money and she had to pay it back. So the wife needed much more than that. And finally, my light just went out, sorry. And finally, with respect to reopening, the wife charged that the husband had lied, had said that Dr. Glodowski was not a client, didn't pay any money. And then after trial, the wife discovered through uncompleted discovery that in fact, he had received money from this doctor. So we asked for a reopening. The judge wouldn't even permit an evidentiary hearing. This was, again, clear legal error. I'd like to reserve my remaining minute for rebuttal. Thank you very much.
Yes, ma'am. All right, Mr. Tyson, you're recognized whenever you're ready, sir.
Yes, Brennan Tice, if I may please the court. I represent the appellee Cormac Barrett. I guess in this oral argument, what I'll do, if it's okay with your honors, I'll just go through the different issues in the same order that Ms. Lippincott did and just address each of them, of course, subject to whatever questions your honors want to ask.
Maybe we can go backwards to propose something completely different. The last issue that Ms. Lippincott raised seems to be a serious one, which is that your client testified under oath at trial that he never got paid by Dr. Glodowski. After trial is over, a subpoena, which had been issued long before trial started, comes back and says, lo and behold, there's $13,500, about $6,000 of which had been paid to him before he testified that he'd never been paid. Now, I understand that your client may have an explanation for this, but he may not. In your brief, I think you fall back on general credibility determinations. But I wonder if you could address for me how this isn't at least arguably fraudulent testimony that merits an evidentiary hearing.
Well, I think the issue is the materiality of it. They filed a motion to reopen the evidence, and they want to basically, you had your trial, you had 2 days of trial, and now you're saying, hey, we found this evidence. We want to reopen it and start the trial again. And you have to look at the enormous amount of discovery that was done, the enormous amount of evidence that the wife put on in support of her determination of the husband's income.
With materiality, and again, I'm not sure what an evidentiary hearing would show, but would an extra $5,000 a month of income to your client, for argument's sake, reflect a material difference in what the available ability to pay would be for alimony?
I don't believe so, and that's sort of my point. So I think the evidence that they presented, true or false, said that they showed or they purported that there were payments from Dr. Glodowski of $13,275 during that year, 2019, for the entire year. And like Your Honor said, $5,500 of it, if it was truly income or revenue, it was post-trial. So if you span that out over the year, you have a little more than $1,000 of gross income. Gross income. Remember, this is not, as the evidence showed, Mr. Barrett had expenses that would have reduced that gross amount. So, and that was only for 1 year. So, I mean, if they had, remember, he's in a business where he's self-employed, and so just showing $13,000 of payments over a 1 year period of gross income is probably not going to, I don't think, rises to the level of materiality that we now have to reopen the evidence.
Mr. Tyson, I've got a question for you, Mr. Tyson. There was the issue of the motion for continuance, and a lot of that hinged on the other subpoenas that were out as well. You recognize that issue, is that correct?
Yeah.
And actually, hold on one second. That subpoena actually came back with some material evidence as far as finding some income, but there were still the other outstanding subpoenas. The court denied the motion to continue, and you went on because you had a multi-day trial. I'm very concerned about the overreaching theme of this case, which appears to be the lack of candor and the lack of truthfulness from your client. That seemed to be a theme throughout the discovery in this case. So it's not just that one subpoena, but it's the ones that were not effectively processed to provide discovery, and makes me wonder what else is out there as support for this issue as far as, Ms. Lippincott was saying flat out fraud on the court. So could you please address that, sir? I'm very concerned about that in this case.
Well, let me just point out one small fact. There were 36 subpoenas issued during the course of the case. There was, I think, 25 here in Florida, and I want to say 11 that were served on in New York. They asked the court to appoint a commissioner. So there was a lot of subpoenas. Now, I'll address specifically the motion for continuance. That's what Your Honor brought up. In their motion for continuance, the basis for continuance was that there was 3 subpoenas outstanding. One was Dr. Glodowski, which we know, they obviously got those records because that's what we were, just talking about. The other two were for a Dr. Fagan and a all family medical or all family medicine. Dr. Fagan, they were saying that the subpoena was still outstanding, but if you look at the wife's expert's report, his notes indicate that his findings of income, the expert, was based on information from Dr. Fagan. There was a letter from Dr. Fagan to, I think, wife's counsel dated September 9th, 2019, which indicated that the husband was getting paid $12,000 a month from Dr. Fagan. And that was part of the evidence or documentation that the wife's expert used to formulate his opinion. So clearly, they must have got something regarding Dr. Fagan. The third subpoena was regarding all family medicine, which relates to a doctor, probably saying this incorrectly, but Dr. Ionescu, who was one of the three doctors that was a client of the husband and did provide revenue to him. And again, the wife's expert report included income from Dr. Ionescu. In fact, the wife's expert's report indicated that the husband was getting monthly revenue from Dr. Ionescu of just a shade under $4,000 a month. So the basis of their continuance, it appears that they did have records regarding those doctors. They had the opportunity to subpoena those doctors to testify at the trial. They chose not to. And so now they're coming in and saying we didn't get records on a subpoena. And to answer Your Honor's, inquiry regarding sort of the theme of the case, it was the wife's contention that the husband had not been forthright and had not produced discovery and was not being, upfront about income. But the evidence at trial, the husband had an expert too. And his expert indicated that he had went through the husband's QuickBook records. He went through his tax returns, went through his bank statements. And the husband's expert indicated that I did not see payments from Dr. Glodowski. I didn't see payments from, I think it's Dr. Castiglia, who was the other disputed doctor. The husband's expert also indicated that the husband doesn't even do his own books, that the husband's accountant does his books and keeps his general ledgers and his QuickBooks. So I understand the wife made that a theme, but the court heard the testimony, the court looked at the evidence, looked at the overwhelming amount of discovery that the wife's expert was privy to, and the court found the husband credible. So, that's sort of what happened in this case.
Is the trial court's finding of credibility potentially affected if it turns out he was lying under oath?
Well, depending, yeah, absolutely. I think that would affect it, but would it affect it to the extent that it would change the outcome of the case? I think, again,
we have some precedent that suggests that when a Rule 12 it's a Rule 1.540 motion is filed that alleges fraud with particularity and specificity, that the trial court shall conduct an evidentiary hearing. I understand that you're making, and I don't know if you're familiar with that case law or not, but I hadn't seen anything that suggested that the trial court at that point needs to be concerned about materiality. In other words, the question appears to be binary. Is there fraud alleged with particularity and specificity? Not, if so, is it a big fraud or a little fraud?
Well, what I was going to do is bring the court's attention to the elements when the court has to address the motion to reopen. The case law, which I cited in my answer brief, kind of spelled out the exact the elements. And the elements, I'm getting right to the point of my brief that talks about it.
There's an element.
Yeah, I'm sorry, go ahead.
There's an elemental test, a 4-factor test that kind of jumps from a 2-factor test, which relates to 12.530, which is the motion for rehearing. And then you've got 12.540, which looks at it through kind of a different lens. I didn't mean to interrupt, but and if I'm not seeing it correctly, please correct me.
Well, their motion that they brought before the court was a motion to reopen the evidence. So what I was going to address were the elements related to that. Now, of course, Your Honor is right. You could bring a 1.540 motion, I think, up to a year or something like that. But I still think even if you bring a 1.540 motion and say this party lied, there's still some element of materiality. I mean, let's say if it doesn't give you the opportunity to reopen the entire case. If, maybe it's a for example, but let's say in a divorce, you've got the parties own millions of dollars of assets, and the husband, lied about the value of a bank account by $5,000 or $10,000. Yes, if he committed fraud, that's inappropriate. The court could certainly take that into consideration. But the $5,000 or $10,000 in a bank account, wouldn't be such an egregious thing that we need to reopen the entire divorce and redo the equitable distribution, or in this case, reevaluate the income. So I think that's the issue.
I don't necessarily disagree with you with that premise, but I think that premise is also grounded on the idea that the court won't know what remedy to impose until after it has the evidentiary hearing. Is that a fair statement?
Of course, and that's we're presupposing that the husband did commit fraud, and I'm not saying he did, but I think the reason the court doesn't have to get into it is because assuming he did, and assuming he got $13,000 of gross income from Dr. Glodowski for 1 year, and half of it was after the trial. So arguably, the only fraud there would have been is the $8,000, little less than $8,000 that he received in gross income revenues before the trial. Is that $8,000 such that now we need to reevaluate the entire award? I think my position is I don't think so. And I think the court had the discretion based on the case law that if it did not determine the materiality of it and the fact that there was so much evidence presented. I understand the argument of the wife that, there was other discovery and there could have been other things out there, but you have to look at how much discovery was done by the wife, and an immense amount of discovery, and their expert was privy to an immense amount of documentation. Just looking at the expert's report, he indicates that the basis of his opinion was based on tax returns for 4 years, bank statements for 4 years, QuickBook records for 4 years, subpoenaed records. I mean, the wife's expert, whose income was actually accepted by the court. What the judge did is she actually accepted the wife's expert's income as to gross income before taxes. So I think we have to, I think you have to look at that small issue of Dr. Glodowski in the totality of what was going on in this case. This was a 2-year litigation where there was an enormous amount of discovery. If it's okay with you.
Can I ask you, Mr. Tyson, just to switch gears for a second and discuss the first issue that we spoke to your opposing counsel about? Judge Nardella did a lot better than I did. Who owns the house?
I think right now it's titled as tenants in common, husband and wife, because the final judge, it was tenants by the entirety, obviously, before the divorce. Now there's a final judgment dissolving the marriage, and I think by operation of law, they're tenants in common.
So you would agree with Ms. Lippincott that your client still has an ownership interest and still is the co-owner of that house?
He has a legal interest, I believe, in the house. Correct.
And that's based on what she said, the final judgment that basically conditions his execution of a quitclaim deed following the payment of the equalizing amount?
I agree with that statement. I think that what the court was doing, in essence, by leaving it as tenants in common, was in essence providing security, which is very common in divorce cases, so that some person is, parties ensure that they could receive their equitable distribution. If the court put in that language, the conveyance language, and now the wife is the 100% titled owner of the property, the husband basically has no recourse to be able to obtain his equitable distribution. And the case law is very clear that the court, when fashioning an equitable distribution award, is supposed to fashion it in a way so that the parties have a reasonable opportunity to get what they've been awarded. If you gave the wife the house, there weren't any other assets that the wife had. You have the house, There were some retirement funds, but those were to the husband. Then you have the husband's business. So if the court awards the house to the wife, the husband's basically without a remedy and without an ability to collect on the $270,000 that he was awarded. And so the statute 61.075 is very clear. The case law is very clear that a court can engage in a number of different methods to ensure a party is able to get their equitable distribution. The court can order a note and mortgage be executed. The court can order a bond. The statute specifically talks about security. And so what I think the court did was the most practical method of ensuring the husband can collect on what he was awarded. I thought that the court did it in a very simplistic way. If the court took one of these other remedies, equitable lien or one of these other things that the court could have done, it would have made things even more complicated. What the court did was very simply and said, yeah, I'm awarding you the house. However, it's contingent upon you paying Mr. Barrett the $275 or whatever that number was.
So when you talk about a security interest, we talk about sub 10 of the statute. I think I'd suggest that there's a difference between a mortgage, which is a security interest that is owned by somebody who doesn't own the property, versus a co-ownership situation, as both sides are suggesting exists. Is there a vehicle under 61.075 following a judgment which says I award sole property to the wife, the marital residence, to allow your client to continue to be a co-owner, not a security interest holder, a co-owner? How does that not run afoul of the plain language of the statute?
Because what the court did is kind of leave. I think my position and our position is, and I think the final judgment speaks for itself. The court's intention was not to award the wife the home in the sense of she's getting sole fee simple interest in the home. I think the intentions of the court, and I thought it was very clear, was yes, it's sort of like an exclusive use. We're going to give you the house, but this is the condition upon which you're going to get a fee simple interest in the house. So the final judgment. I'm sorry.
Our question, Mr. Tyson, is not what the court's intention was, but what did the court actually do in reference to what has been called the automatic conveyance statute?
My position and my reading of the final judgment, and I think the clear reading is, while the court awarded the house to the wife, it was conditioned upon her paying the equalizing payment. And the mechanism to ensure that would take place was to leave them basically as tenants in common, like they are, because now the husband has some cause of action. He's a co-owner. He could sue for partition. He can do something to enforce his $270,000. If the court said, okay, we're going to put that language in there, and now the wife is 100% fee simple owner, the husband has no remedy. There is no security. The court could have done like Judge Traver mentioned and said, okay, let's follow the statute and let's make her sign a note and mortgage, and the note becomes due in 6 months. And then the note doesn't get paid in 6 months, and then now the husband has to foreclose on a mortgage. I mean, I think that's just cumbersome. I mean, the court could have done that, but I think what the court
How is that any less cumbersome than suing for partition?
Well, because suing for, the reason I would say it's less cumbersome is now you've got a note and mortgage action. You got to enforce it. It's a contract action to some extent. A partition's is sort of cleaner in the sense of that. Let's just order it sold.
Based on the way that you're, sorry, Judge Nordella, go ahead. Based on the way that you're reading the amended final judgment, Mr. Tyson, does any sale or encumbrance of that house require your client's participation?
I'm sorry, can you read? I'm not sure I understand the question.
Yes, sir. So say that, what the judgment says is he delivers the quitclaim deed within 15 days of the equalizing payment, unless the house is sold. Based on how you're reading the judgment, does the sale or potentially the encumbrance of the house require your client's participation?
If she was to sell the house right now, yes, I think he's a co-tenant or I'm sorry, co-owner. I'm sorry. Yes, I think he's got a legal interest, and he would have to probably join in on the deed so that it would be, transferred to the new owner.
Mr. Tyson, did our trial court have the power to do what it did in this case? Was it exercising power out of equity or out of statute to delay the execution of the quitclaim deed?
I think it's both. I think the court has the authority under 61.075 to order security. And so while it didn't, like I said, it didn't order a security interest per se, it ordered security no different than if a court was to order life insurance or an equitable lien. A court has the authority under the statute, under the case law, to impose an equitable lien on homestead property. And so the court, again, our position is that rather than going to some remedy such as that, the court used a more, simplistic approach. Considering the amount of litigation that went on, anything it could have done to simplify the enforcement of this judgment would probably be a good thing in this case.
All right, sir, you're over time. Thank you for your presentation. Ms. Lippincott, Marshall Crawford, I just asked that you give her an extra 45 seconds to make it equal. Go ahead, ma'am.
Thank you, Your Honor. Yes, the wife's attorney had to do a great deal of discovery here to try to determine what this self-employed husband earned. Indeed, the trial court found that although he only disclosed $6,700 in income, he made at least almost $15,000 a month in income. She shouldn't have had to do any of this discovery because he should have supplemented his answers and told the truth. He didn't do that. And the reopening was not for a minor matter. If you'll recall, at the trial, there was documentary evidence that the wife introduced that Bar Medical was charged approximately $100,000 by the Henry Schein Company for Dr. Glodowski. There's more here that needs to be discovered. Thank you, Your Honor. We'd ask for a reversal.
All right, thank you both very much for your presentation, and we'll be adjourned.